The first death penalty case I'm going to talk about is Madison versus Alabama. And this is a case in which Mr. Madison is basically saying that he is incompetent to be executed. So that's the issue that the court is facing. Mr. Madison was found guilty of killing a police officer and sentenced to death 3 times. He had 3 trials. The first time was in 1985. He was convicted, but his conviction was reversed by the Alabama Court of Criminal Appeals based on a Batson violation. Some of you may know the case Batson versus Kentucky, in which the United States Supreme Court held that an individual may not be struck from a jury based on his or her race. And in this instance, all 7 African-American members of the jury pool were struck by the prosecutor. And even the Alabama Court of Criminal Appeals found that that was reversible. So then he had his second trial, and in his second trial, his defense was that he was not guilty by reason of a mental disease or defect. He was convicted again, sentenced to death again. The Alabama Court of Criminal Appeals again reversed his conviction, this time based on prosecutorial misconduct, which must have been pretty bad because it's really difficult to get a reversal based on prosecutorial misconduct. So then he had his third trial in 1994, and at the third trial, his defense was that he acted in self-defense. Remember, he killed a police officer, which is, of course, one of the crimes for which prosecutors frequently seek the death penalty. He was found guilty a third time, this time during the penalty phase, and everybody knows how death penalty cases work. It's a bifurcated trial. There's what's called the guilt phase, which is just a regular trial where the jury decides whether the person's guilty, whether the government's proven that person's guilt beyond a reasonable doubt. And then the second phase, if the person's found guilty, the second phase is what's called the penalty phase, or the death phase, as some people call it, where the jury decides whether the person gets the death penalty or life without parole. So in this third trial, during the penalty phase, which is when the government tries to prove a number of aggravating factors and the defense then presents what they consider to be mitigating factors, and then the jury weighs them in deciding whether the person's going to get the death penalty. So during the penalty phase this time, Mr. Madison put on a great deal of evidence about his mental illness. He had mental illnesses for a good part of his life. He'd been on a lot of numerous medications, and based on that evidence, the jury decided that he should get life without parole instead of the death penalty. However, in Alabama, they had a practice called judicial override, and in which the judge could actually override the decision of the jury in death penalty cases. And Alabama is the state that was most notorious for using that. I think Florida had that provision, as did Delaware. No states have it now. In fact, even Alabama abolished it last year, but they did have it at the time of this trial, and the judge overrode the decision of the jury to sentence him to life without parole and sentence him to death a third time. So then in 2016, Alabama moved to set an execution date, but during that time, at the same time, that year, Mr. Madison's lawyer filed a petition to stay his execution based on his severe physical and cognitive decline. He'd had numerous strokes while he was incarcerated. And one of them was something called a thalamic stroke, which really destroys the brain tissue and causes you to lose your memory. And he had absolutely no memory of committing the offense. And so a Mobile County judge decided to allow a competency hearing to decide whether he was competent, and appointed an expert, a doctor, Dr. Carl Kirkland, to represent the state and to evaluate him, Mr. Madison, and give testimony about whether he was competent to be executed. And then the defense hired an expert, Dr. Goff, and they both testified, Dr. Goff saying that he wasn't competent, Dr. Kirkland saying that he was. It was undisputed at that time that he'd had numerous severe strokes that had left him legally blind, with significant memory loss, significant cognitive decline. He had what's called vascular dementia. He was unable to walk on his own. His speech was severely slurred. You couldn't even understand him, and he was incontinent. Nonetheless, the court accepted the finding of the state's expert, Dr. Kirkland, and found that he was competent. Now, it was later discovered that just 4 days after this hearing, Dr. Kirkland, who at the time, well, let me just back up. It was later discovered that Dr. Kirkland was a drug addict. And then that just 4 days after this competency hearing, in which he testified that Mr. Madison was competent, he forged some prescriptions to get drugs and was ultimately charged with 4 felonies and was suspended from the practice of psychology. So that's the doctor on whose expert testimony the judge relied in deciding that Mr. Madison was competent. So these are the issues that will be decided by the Supreme Court. Whether the state may execute a prisoner whose mental disability prevents him from even remembering the offense for which he was convicted, and whether the Eighth Amendment's prohibition of cruel and unusual punishment bars the execution of a prisoner whose mental condition prevents him from remembering the crime and even from understanding the circumstances of his execution. And this is not the first time the court has ruled on the issue of competency to be executed. In Ford versus Wainwright and Panetti versus Quarterman, the court addressed that issue and held that a person who is mentally incompetent cannot be executed, but the court was not clear about exactly what mental defects make a person incompetent. And so Mr. Madison is very ably represented by the great Brian Stevenson, who some of you may know from the Equal Justice Institute, who's Equal Justice Initiative, I think, not Institute, Initiative, EJI, who has a great record of winning cases in the United States Supreme Court, death penalty cases. And he's arguing that there's no deterrent value, no retributive value to executing someone who's in Mr. Madison's condition. The state, on the other hand, is arguing that Mr. Madison is competent, and the fact that he can't remember the crime does not make him incompetent. And they're also arguing that retribution has a value, and they're also arguing that there is a general deterrent value, that others will be deterred from committing this crime by his execution. So